All rise. The Court of Appeals Division 1 is now in session.
Thank you. You may be seated. We are here today in our case number 140137, State versus Stephen DeMacher. These proceedings are being audio and video recorded, so we'd ask when you approach to please identify yourself and your client. We have conferenced this matter. We've read the briefs and have discussed the issues. With that in mind, we'll look forward to your argument. Counsel, obviously, if you're going to reserve time for rebuttal, that'll be up to you.
May it please the court, I'm David Goldberg. I represent the appellant, Stephen DeMacher. And I do want to try and reserve 5 minutes, see how it goes, whether we get 5 minutes. This case, the murder case, is one of circumstantial evidence. It's clear. If you've read the briefs and you've read the record in this case, there's no direct evidence linking Stephen DeMacher to the murder or the murder to him.
But I thought we don't really distinguish between direct and circumstantial evidence.
Of course not. But the court can consider the circumstantial nature of the evidence in looking at the two issues that I hope we have a sufficient time to discuss here today, and whether the errors that were made, the legal errors, first in joining all of these counts together, all 10, and secondly, in allowing the murder charge to go forward after the prosecution went on a path of purposely goading prior counsel 52 days into a trial to move for a mistrial. And I'd like to take those in the order that I just presented them. First, the severance. Now, taking a step back, I think what the fundamental disagreement here between the state and the appellant is what law this court should apply here. For example, on the severance issue, the state cites, and they cited below, Martinez v. Villarreal, which is a 1985 or 86 case out of the Arizona Supreme Court. A lot of law has developed in this area since then that should guide this court's decision here. The trial court, first of all, under an abuse of discretion on this issue, did no analysis, did not analyze the issues, even though they were both briefed in the motions that were filed and the response and the reply. Meaning, the court simply skipped right to the 404B issue and said first of all, that it was an all or nothing proposition of the court. Either he was going to be found guilty of all 10 counts, or he was going to be found not guilty of all 10 counts, which is completely inaccurate.
Didn't the court also suggest that the evidence would have been separately admissible if they'd been tried separately?
Correct, but that's not the analysis under Preon. That's the analysis for this court on an error. So I'm submitting initially that the trial judge abused its discretion by applying the wrong legal standard. The legal standard is that you don't skip to the 404B, and Preon advises us that the standard is much more strict than Villarreal, which is what the state wants. It's not just that there's some logical connection, because the trust involved the victim and the victim of the murder, there's an appearance of a logical connection there, but there has to be much, much more under Preon. Secondly, you don't go to the 404B issue until you've decided in the first instance that they are properly joined, that there is, and this is in the words of Preon, so intertwined and related that much of the same evidence is relevant to and would prove both, and the crimes arose out of a series of connected acts.
How about on the voice in the vent evidence? Would that have? What's your best argument for why that should not have been tried at the same time?
Why that was not cross-admissible? Because the voice in the vent evidence was if you assume the facts as averred at the time that the motion was denied, Mr. DeMacher heard this, fabricated it, put it in an email to get somebody else investigated for the crime that he believed committed it 10 months after the state had filed the charges, asserted the death penalty, and was proceeding all the way up through voir dire with the death penalty case. So the jury could find, yes, he did this, but his intention, just as was argued, was to defend his life. Not that he somehow, because he knew some things about the murder, and that's what the trial judge kind of glommed onto here, he had all the discovery for 10 months. They were in court repeatedly. This was a heavily litigated case with 3 lawyers on the defense side, 2 lawyers on the prosecution side, all of them very experienced lawyers, and the court can take judicial notice of all these people that are mentioned here, including now Judge Butner, who was the lead prosecutor, and Larry Hammond from here in Phoenix. So there was a lot vetted in the courtroom about the facts of this case. And Mr. DeMacher was very involved, and the record bears this out, in his own defense. And so he knew all these facts. So even if you assume, and we should at this juncture on appeal, that he fabricated the voice in the event, that doesn't necessarily mean that it proves what the trial judge assumed it proved, that he was the only one who knew the facts of the murder scene, for example.
Well, but the talker was aware of the circumstances, though, and properly took account of them, right?
I'm not sure I follow your question, Your Honor.
I mean, you said that your client was already aware of the information that of the facts of the crime from being in court, correct?
And being provided the discovery for over 10 months prior to the voice in the event ever surfacing.
But the trial court understood that when it made this ruling.
I don't believe it did. The record will reflect that at the record 12/22/11 at page 33 and 35, where the court's making its ruling, it's making certain assumptions. And you have to recall the procedural history here. We went through 3 judges in this case. The first judge unfortunately passed away after taking ill halfway through the first trial. Then Judge Darrow took over in the second trial. And now the judge that's speaking here is yet again not familiar with all the facts, did not sit through the trial, so we cannot even, from its inception, cannot presume that the court knows that. The court was making a presumption here that only Stephen DeMacher, for example, could know what the facts are in the voice in the event because he was the one who was there. In other words, he's pre-assuming his guilt. And this is now 3 years post-date of defense. All right?
Did counsel make that argument to the trial judge?
Yes, the counsel made the arguments in both writing and briefly orally because it was clear that the judge was, from the inception of the oral argument on this, if you look at the transcript, it's only 3 pages on a severance motion. By the time we get to trial, and former Judge Donahoe was presiding over the trial, at the point that defense counsel gets up to move, as he must under the rules, to re-urge his motion to sever at the end of the state's case, at the end of the defense case, he says, I don't want to hear about the severance anymore. I know what you're saying. It's denied. They didn't want to even hear about it. The more problematic issue here is joining what was count 3, the trust. And that's a reverse in logic, okay? What the state is saying is that it is interconnected with the murder because the motive for the murder always was to get the funds that Stephen DeMacher had no legal right to. And the evidence is unrebutted in that regard that was presented during the trial, which is as soon as they were divorced, which is in April of 2008, Stephen DeMacher lost all legal right to the proceeds of the trust and the proceeds of the insurance and tried to disclaim it repeatedly.
Why did he keep making payments? It's a term life insurance policy. Was that part of the divorce agreement that
they were separated up till then? And April, so the chronology here is that in April the divorce was final. He made his payments of what he owed the decedent, meaning he gave over his IRA, or 401k, I believe it was. Then the murder was less than 3 months later. So he wasn't making the payments, obviously, up till October when he was finally arrested, when he was out before the state actually charged him and put him into custody. This trust money is the heart of both issues here. And I do want to get into the second issue as well, which is the trust money was used to pay for his lawyers, period. It doesn't show a consciousness of guilt. It's not linked to some predisposed motive which doesn't exist. Because that's the basis of joining count 3 with the murder counts, which is that's the motive for the murder. But he had no legal right to it. How could he be motivated, logically or legally, to kill somebody
Wasn't there
for
some
money that he was not even entitled to?
Wasn't there testimony, though, that he told his daughter that he had plans for that money, asking her to, I guess, to use it, that he'd been making the payments and that he needed the money?
He needed the money to defend his life. That's why there is no cross-admissibility here. Because or the judge's reasoning, the trial judge's reasoning doesn't really hold water, which is if Mr. DeMacher 10 to 12 months later, when he's facing a death penalty case with private counsel, and this court knows as well as I know and the state knows, you don't defend a death penalty case on a $25,000 retainer, or maybe even a $700,000 retainer, which is what the private defense lawyers in this case received ultimately to defend his life. That's why most of the death penalty cases in this jurisdiction are tried by appointed counsel, because they are so expensive.
So if he had not been tried for murder, then he would not have attempted to persuade his daughters to provide him with the funds from the trust?
Correct. The legal implications are, if he had just been charged with, for example, murder without a death penalty allegation, then there would have been a host of issues that would not have ever occurred in this case. For example, the issues that arose that were the subject of 3 special actions in here involving in the history of this case, involving whether he was entitled to indigent funds from the county, from Yavapai County. And secondly, whether he had to hire lawyers, a team of lawyers, as required by the AAB defense guidelines for death penalty cases, 2 or more lawyers to work up a mitigation case while they were working it up. There wouldn't even be any need for a penalty case. So it wasn't until the state pursued that path and pursued the death penalty, and he retained the best lawyer, which is his Sixth Amendment right under Gonzalez, to represent him, and his parents could not fund it anymore, that this motive or intent arose. It didn't arise back in July of 2008. It arose when he was in the jail discussing this with his daughter.
Well, counsel, I understand that that was your client's position then and now, but isn't the state entitled, based on the evidence, to argue that he always had designs on this money, and his initial disclaimer of the funds was just a part of his plan? And I'm not saying that that's the only interpretation that can be made from it, but why isn't that a reasonable interpretation that can go before the jury?
Well, that presupposes, that's a reasonable argument, but it presupposes that these are 2 connected incidents under Prion. Under Prion, and I'm strongly arguing here that Prion is what guides this. And the cases that follow Prion, more recently, State versus Burns upstairs in 2015, that you cannot cure the harm of joining all these unrelated things. If the only evidence is that he created the voice in the event and used his daughter to create the email, and that's supposed to show a consciousness of guilt, that still doesn't get us there. That only gets us to whether it's reversible error per se. It doesn't get us to were they actually joined in the first instance. I'm not conceding the former, obviously. In the latter, there is no interconnection between those 2 events, as I argued before. I do want to spend just a couple of minutes on the mistrial issue, because this is the one I actually put in my moving papers for oral argument. And I think the legal issue here for this court is, and perhaps depending upon the outcome of this case, for the Arizona Supreme Court, and perhaps maybe even the U.S. Supreme Court, is what is the standard for determining whether double jeopardy bars retrial in this case? And my suggestion is that, first of all, the state has waived argument on this because they didn't respond to my specific opening brief arguments, which were that Poole and Hughes and Jorgensen and that line of cases out of Arizona is not premised on the Fifth Amendment and the 14th Amendment of the U.S. Constitution. It's premised on the double jeopardy clause of the Arizona Constitution, which they have limited to those circumstances. The Kennedy case, Oregon versus Kennedy out of the U.S. Supreme Court, is a much more general standard, but it adopts the Dimitz case, which is an earlier U.S. Supreme Court case, and it also references a couple of Ninth Circuit cases, which I put in the briefs, which asks you to look at the totality of the circumstances here, which was argued from the inception by original defense counsel, meaning you look at what the state did throughout the case, and I put all the cites in my reply brief, and I don't have really enough time to go through them all, but what these cases properly right here would have told the trial judge, which the trial judge basically just only ruled based on Hughes and Jorgensen, that he found no intentional misconduct, similar to what this court found in Mielke in more recently, but that you look at how was the trial going. The first trial was 52 days into trial. Throughout the trial, the state was losing. The state had no response to the DNA evidence that was under the victim's fingernails, and the defense was that that's the person that killed the victim.
Counsel, let me ask you, you mentioned totality of the circumstances and the assessment of the evidence and sort of how the case was going. Doesn't that suggest the trial court is in the most appropriate place to evaluate that?
If the trial court, in fact, did that. And if you look at the ruling in this case on this issue, the trial court did not.
How do we know that?
Because the language the court used, the language in the oral arguments on this issue, specifically September 27, 2010, between pages 4 and 34 was when they were arguing this issue, does not reflect that. The judge kept saying, well, I don't find anything similar to what the prosecutor, what I believe it was Mr. Peasley down in Tucson did I think in the Jorgensen case. I don't find that there was suborning perjury or there was fabricating evidence or like what happened in Mielke here, whether there was withholding exculpatory evidence for how many decades? 2.5 decades for Ms. Mielke. That's why I'm saying the court, whether this court reviews it de novo or abuse of discretion, it doesn't make a difference. The court applied the wrong standard here, so the court did abuse its discretion. Because the U.S. Supreme Court, in terms of what the Fifth Amendment and the Sixth Amendment mean here, because they're both implicated, is what matters. And what they said is you just look at the totality of the circumstances to see if the prosecutor goaded the defense into filing a motion for mistrial. How could the defendant go forward 52 days into trial when the state was listing the defense, Mr. Sears, as a witness, filing bar complaints down here in Phoenix repeatedly through the sheriff and through Ms. Polk, and objecting repeatedly to the fact that they can't get in the Hartford evidence, which they knew about from the inception of this case, and the judge kept shutting them down on that. The case was going south for the state. And an experienced prosecutor,
What's the timeline on the voice in the vent evidence?
The voice in the vent evidence came out originally in 2009, or in late 2009 to 2010. And what happened was the state listed Mr. Sears as a witness to it because he's the one who brought it to the attention, and they had a free talk prior to the first trial ever even started. So it was already known before the trial. The voice in the vent and the email evidence were known. That was just repeatedly kept out, except for the email evidence, which the defense wanted in as exculpatory. The court initially allowed in and then left out. So you follow follow the trail of evidence throughout this case, what the state knew and how their case was basically going south on just the murder charge, and how it now look at it compared to trial 2, where they have 7 other counts that show in their own argument here on appeal consciousness of guilt. To bootstrap a otherwise, and this gets back to what I said originally, a highly circumstantial case of murder and make it stick when it, otherwise on its own merits, we would never be here because he would have been acquitted in the first trial. I want to reserve the last 58 seconds, like usual.
May it please the court. Counsel, David Simpson from the Arizona Attorney General's Office on behalf of the state. I'd like to start by clarifying a kind of a factual issue in the record, and then I'll discuss the severance claim and the double jeopardy claim. So regarding the factual issue, I wanted to address whether the defendant was eligible to take from the victim's life insurance. That goes to a number of issues in the case. Now, the state presented evidence below that the victim had a motive, that the defendant had a motive to take from the victim's life insurance. And now the defendants asserted on appeal that he had no right to take from the victim's life insurance because they were divorced. And he also asserts on page 27 of his reply brief, and I'm quoting here, the trial court found the law is clear that Mr. DeMacher lost any rights to the life insurance proceeds once the dissolution of his marriage to Carol Kennedy was final. Now, with respect, Your Honors, those assertions are mistaken. First, the trial court never, quote, found the law is clear that the defendant lost his right to the victim's life insurance. The trial court order in question is record entry number 892, although the reply brief mistakenly cites to it as 882. That order merely noted that the defendant's defense counsel had argued that he had no right to the life insurance. The trial court never adopted that conclusion itself. Moreover, if it had adopted that conclusion, it would have been wrong. ARS section 142804A1A says that a divorce, and I'm quoting again, and this is the last time, revokes any revocable disposition or appointment of property made by a divorced person to that person's former spouse in a governing instrument. And the rationale for that rule is based on a common sense inference about the intent of the giver. So if my wife names me in her will, but we divorce before she dies, the gift to me would be revoked by the statute. We presume that she intended to revoke that gift by divorcing me. Or suppose my wife took out a life insurance policy on her own life and named me as a beneficiary, then divorced me. Again, that would be terminated under the statute. Now imagine a different situation. Imagine I take out a life insurance policy on my wife's life and name myself as a beneficiary. That would not terminate under the statute. I'm the owner of the policy and the beneficiary. We would not presume that I intended to revoke the gift to myself. This second situation is what happened here. There's no question that the defendant's not entitled to take from the victim's estate, but he's still entitled to take from the life insurance because he is both the beneficiary and the owner of the policy.
Which is consistent with him disclaiming
Exactly,
an interest.
exactly. So the policy documents, by the way, are trial exhibits 8 and 10. And yes, that's consistent with the fact that he continues to make payments on the policy and the fact that he submits a claim for the policy after the victim's death. That's why the state's financial expert included the policy in its calculation of what the defendant stood to gain through the murder. That's at the trial transcript for August 20th, 2013 at pages 55 to 58. Now, the reason the insurance company didn't pay out on the policy is not because of the divorce, it's because of the Slater statute. The defendant's still a suspect in the victim's murder, and that's at trial exhibits 18 and 20 through 23. So the point is this. The defendant was legally eligible to take from the victim's life insurance. Finally, it's worth noting that even if the defendant was not actually legally entitled to the money...
Well, and counsel, the disclaimer came, obviously came after the murder.
I'm sorry.
The disclaimer obviously came after the murder.
Right. And that goes to the second point, is that even if he's not actually legally entitled to it, he believes he subjectively believes that he's entitled to it. He makes a claim and then makes a disclaimer, and that the jail calls amply established that he subjectively believed it's his. So as a result, I mean, the evidence is admissible to show his motive, regardless of whether he's legally entitled to it or not. If your honors don't have any questions about that, I'll move on to the severance issue. I think the easiest way to address the severance issue is under 404B principles. Cases like Prion make clear that even if cases are improperly joined, the error is harmless if the evidence would have been cross-admissible anyway. And that's exactly the case here. So his falsification of evidence shows his consciousness of guilt for the burglary and the murder. His financial crimes show his motive for the burglary and the murder.
And why does it necessarily show consciousness of guilt to fabricate, say, the voice in the vent evidence? Isn't it just as plausible that he's simply facing the death penalty and looking for a way to avoid being convicted of something that he didn't do?
That's another possible interpretation, Your Honor, and that would just go to the weight of the evidence, not its admissibility under 404B. So it's frequently the case that you have someone who may have a motive to, say, run from the police because they don't want to get arrested, but if they also have outstanding warrants or something of that nature, then that gives them an additional motive to flee from the police, and that would be admissible. The same sort of thing here. The fact that there are other interpretations to the evidence.
Isn't the flight usually before charges are brought?
No, I think it would go to either way. I mean, and just as a common sense inference here, one could infer that he was engaged in this because he knew he had been caught and was trying to get out of what he was doing. And whether it's before or after the charges, I don't see why that makes a difference, particularly in terms of the inference that you're drawing.
I would think it's a more compelling case of consciousness of guilt if someone is fleeing before charges are brought. You're just suggesting there's an anticipation that charges will be brought.
Right. I mean, they're trying to avoid punishment. It's whether the punishment, the degree of certainty of the punishment. Again, I mean, that's, I guess, something you could throw in the hopper, but I don't see why that's inherently more or less probative. I mean, if anything, the fact that he's
I've forgotten the timeline on the motorcycle and the cash that's hidden with the motorcycle in the map of Mexico. When was that?
I believe that would have been in fall, so the murder takes place July 2nd. I think he's arrested in October, and that's when a lot of these activities are going on.
So that also is after the arrest, then?
Correct. But he's making preparations for it before the arrest. I mean, the motorcycle doesn't do him any good. It's discovered after the arrest, I believe, but he's obviously making the preparations before he's ever arrested. Regarding timelines, too, I did want to just clear up, you had asked a question, Judge Kitani, about the timeline for the voice in the vent story. So the issues with the insurance proceeds begin in the fall of 2009. The voice in the vent email was sent on June 19th, 2009. And the first trial starts on May 2010. So it's almost a year later, but it took over a year for the state to fully investigate it. So initially, this anonymous email is admitted as a trial exhibit as exculpatory evidence on June 3rd, 2010. The state's still investigating what's going on. And they actually went through and tried to interview every single person who was in the jail with the defendant at the time. So the record's not entirely clear on exactly when the voice in the vent email was disproved. The testimony is that it was roughly a year or over a year, which would put it sometime around June or July of 2010. And this trial ends up being declared in November 12th, 2010. So that's the timeline. So at the time this trial starts, the state is aware of the existence of the voice in the vent email, but they're not aware of who fabricated it. Just as an alternative grounds for addressing the severance argument, Your Honors, so the state sought to admit the evidence here, to join the charges here under A2 as same or connected conduct. I think these are probably more clearly joinable under A3 for common scheme or plan. That's not argued below, but that's another grounds for affirmance under the right result, wrong reason doctrine to just say that these would have obviously been joinable under A3 in addition to A2, in addition to the arguments I made about.
Why is the voice in the vent, why is that a common scheme with the murder?
Because it's in furtherance of his scheme to get away with the murder. Because it's in furtherance of his scheme to get away with the murder. If the court has other questions about severance, I'm happy to address them. If not, I'll move on to the double jeopardy issue.
Actually, one question. My understanding, there's two different bar complaints that are filed, one by the county attorney and then one by the sheriff,
Correct.
the sheriff's department. What happened with the first bar complaint filed by the county attorney?
I don't recall based on the record. I genuinely don't recall, Your Honor.
Am I correct that the first bar complaint had to do with the insurance proceeds, and the second,
Correct.
the manufacturing evidence?
That's what the state figured out first. That's my understanding of the record. But I genuinely don't recall what the outcome was for the first bar complaint. But I do think this is important to clear up the governing legal standard regarding these claims. The defendant must show that the state recklessly or deliberately caused a mistrial for an improper purpose. It's not enough to allege that the state happened to benefit strategically from a retrial, and it's not enough to allege that the state somehow contributed to the need for a retrial by investigating the defendant's own wrongdoing. Here, there's nothing improper about the state investigating the defendant's additional crimes. As a result, there's no double jeopardy problem. Again, I'm happy to answer other questions about the double jeopardy issue. Regarding sufficiency, I'll just touch very briefly on the argument about direct versus circumstantial evidence. The defendant argues in his reply brief that there should be some different standard review regarding circumstantial evidence. Judge Howe, as you pointed out, that's not the law of this state, and it shouldn't become the law of this state. There's no inherent difference in the probative value of circumstantial versus direct evidence. DNA and fingerprints are circumstantial evidence. Even a smoking gun, the classic example of what we use in everyday conversation for overwhelming evidence, is itself circumstantial evidence. The only question is whether the evidence was sufficient to support a reasonable jury verdict. It was here, and that's enough to decide the issue. Your Honors, going forward, I'm happy to discuss any other issues or questions the court may have about the case. Not then we would ask the defendant's convictions be affirmed. Thank you.
I just heard the first argument right now.
Before you start, we'll give you a little bit more time. If you could put a total of 3 minutes on. 55 minutes, 55 seconds isn't long enough to really hear anything.
I talk fast, you know that. The problem with the first argument that the state came up here and made, which is that I just heard it for the first time, is they waived it. You can't raise an argument on oral argument. Secondly, and that's the basic appellate procedure. The time for that was in answering.
Which argument are you referring to?
About the Slater statute and pour over whether he actually had a legal right.
But it is, I understood from the record that he disclaimed an interest in the, doesn't that?
3 or 4 times.
Well, doesn't that suggest that he was still named, and isn't it common knowledge that you don't automatically lose? I mean, you can take out an insurance policy on anyone. It doesn't necessarily have to be a spouse.
You can, but as the state just pointed out, if we want to even address the merits of that, the Slater statute would prohibit him from that. And the state went to great lengths to introduce at trial over objection evidence that he was researching on his computer whether he was even entitled to the insurance proceeds. So the state's making a huge assumption here that Mr. DeMocker somehow still believed that he was entitled to proceeds. The second thing
Why would he do a disclaimer if he didn't think there was some claim that he had to the proceeds?
Hartford wouldn't give the money to the trust, which is what the secondary beneficiary in this case was.
And isn't that a suggestion that Hartford thought that he might have some sort of claim? I mean, you don't typically seek disclaimers from someone who has no claim of right.
Hartford, I can't speak to Hartford.
Well, I understand, but you just kind of did. And
what I'm suggesting is this: he tried to have the money go to the secondary beneficiary, which was the trust under the terms of the life insurance policy. That was not going to happen until he disclaimed his interest.
Mm-hmm.
It wasn't that he was repeatedly seeking to obtain the funds.
I understand that.
So that's why I don't think even if you consider the state's new argument today that it's meritorious. The second thing, more importantly on the mistrial issue, is this: it's not just the intentional conduct; it's the course of conduct here. What the state did during the course of this trial was things that the trial judge, and then now Justice Brutenell were warning them did not need to happen during the middle of a 52-day plus trial, which is continuing to investigate defense counsel, continuing to file, and it was actually 3 bar complaints. The first one was an oral complaint. Defense counsel, Mr. Hammond, actually, on the record, asked, and this is all cited in the briefs, asked the state to defer it. Mr. Butler got up and said, she's not deferring anything. And then the sheriff filed a more expansive one. Then Ms. Polk filed a written one. I don't know, because those are secret proceedings, what happened to those. But none of this had to happen during the trial. Nor did Mr. DeMocker have to be charged with a new indictment and he be arraigned and Mr. Sears be subpoenaed as a grand jury witness during the trial. The statute of limitations on any of these felonies is 7 years. They had 7 more years. They could have finished the trial, which is Mr. DeMocker's right, but they chose to do otherwise, even after being warned. That's the course of conduct, and we can't get Mr. Butler in here and open up his mind to see what his bad intent was, but we can look at the record, and it clearly was to goad Mr. DeMocker's defense team into moving for a mistrial.
But the insurance issue didn't have anything to do with the mistrial, I'm assuming. Everyone was on board, or defense counsel wasn't moving to withdraw. That had been raised, and they were going forward. Am I right that the issue that triggered the mistrial was the voice in the vent evidence?
Both. Bar complaints, I believe, contained allegations of both, and Mr. Butler got up repeatedly during the trial in these sealed proceedings that are all cited of record and said, and raised ethical violations against Mr. DeMocker's counsel for arranging the trust money, arranging the changes in beneficiaries, even to the point of notarizing. They were going to try and call Mr. Sears to say that he notarized one of the disclaimers. None of that was admissible. The trial judge had already ruled, we're not getting into a trial about the Hartford money scheme. Let's move on with the merits of the burglary and murder charge.
But what do we do with the voice in the vent, the fabricated evidence that is presented through counsel? At least it's sent to counsel, and then counsel offers it. Isn't that more problematic?
At that point, the judge actually reversed itself on the state's motion for reconsideration and denied admission of that evidence, so the jury hadn't even heard it. The jury had heard none of that evidence and wasn't going to hear that evidence. And I don't believe, and you'd have to go back to the first trial, but by memory, I don't believe it was raised in opening statement. The whole issue here was that Mr. Sears got up in opening statement of the first trial and said that Mr. DeMocker had got no benefit from the Hartford money. That, all of a sudden, the state said, oh my God, we have an issue that we never dealt with, and then they went out to search for all the documents in the Hartford based on that. And that was one statement in probably a 20-minute opening statement. But they already knew all about the Hartford money. They were recording his jail calls. They knew that the money had changed beneficiaries and poured into the trust, which was the testamentary intent of Mr. DeMocker.
But that apparently didn't goad them into defense counsel into moving to withdraw until it seems like they had a more difficult issue, having presented evidence that they then knew had been fabricated. And then it's defense counsel that moves to dismiss.
That was one of the issues, and it also put them in the Hobson choice of defending their own ethics, either in the bar complaint here or before the trial court, versus the zealousness that they owe to their client.
And I apologize for we're going over, but
we can talk about this issue for a really long time.
I just want to clarify. Do you have any other knowledge of the timeline in terms of when the state discovered that the voice in the vent evidence had been fabricated? If that doesn't happen until during the second trial.
That I believe it does, because the fabrication and that they traced it to the email to the place down here in Phoenix happened during the trial.
Okay, well, so the state, that seems like it's important for the state to be looking into that. It's important evidence, presumably, and when they find out that it's been fabricated, why is that now a problem that's created by the state when it's in fact DeMocker that fabricated the evidence?
Because they moved to reconsider the prior ruling, and there was no harm in stopping right there. Meaning, they didn't have to go forward and then indict and make Mr. Sears a witness to all this during the trial is the point. I'm not quibbling with what Your Honor just said, which is, yes, logically speaking, if Mr. DeMocker fabricated this, then he is to suffer from that. But in mid-trial, where the issues have been narrowed to burglary and murder, and those issues can be addressed after the trial and cured because the state moved to reconsider, and the judge granted the motion to keep out the entire voice in the event evidence. So it wasn't even part of the trial. It hadn't even been brought up at that point, if you read the record carefully. And that's why the judge kept saying, fine, that's your cure. We'll keep it out. But we're not going to keep going down this road where you keep asking me to bring in the money about the trust, to bring in the Hartford documents, to bring in Mr. Sears, to bring in that he fabricated this voice in the event, because it wasn't even evidence that the state needed to rebut at that point. So the only purpose that you can see from this whole record is that they thought they had a weak case here. And the biggest proof of that is what I've cited in the footnote, and I think in the reply brief, which is they got up in closing arguments in the rebuttal of the guilt phase of this trial and argued that the first defense was bogus, that the DNA evidence that they didn't even know was under the fingernails was from an autopsy Dr. Keene did right before he did the victim's DNA. They didn't even know that during the first trial, and all these other things. And now it's Mr. Knapp who's the bad guy, and ridiculing second defense counsel for their defense. I'd ask that you reverse and vacate and dismiss the murder and burglary charges and grant a new trial as to the remaining counts that were not either directed verdict or I think two of them were dismissed for duplicity. Thank you.
Thank you both for your argument. We'll take this matter under advisement and issue a decision in due course. And with that, we're adjourned.